which are NCA's guides.
Every year, a significant number of foreign trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examination.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present and will help candidates overcome these difficulties and obstacles in understanding the course materials and the exam format.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a good track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.
Everyone, and welcome to the introductory class for the Foundations of Canadian Law. In this class, we would be running through the syllabus just to give us an overview of the course materials. It's a 2-hour class, so I'm not quite sure of how much we can cover, but we'll try as much as possible to cover as much as we can. Just generally, I would like to have an understanding of everyone's background in terms of, okay, have you written any NCA exams? Is this your first course? And just how your experience was, if you have written. So, Somi, do you want to go first?
Yeah, sure. So I was called to bar in 2014 in Nigeria, and I moved to Canada, I think, over a year ago. I wrote the criminal law exam in January, I think. Yeah. So that was the first one, and then I'm taking this one, and I think it's administrative in June. So yeah, that's about it.
Right. Thank you, Tommy. Dara?
Sure. So I've taken 3 NCA exams, and I have 2 to go, which is Foundations and PR. And I've used NCA guides for almost all of them. Yeah, so.
Perfect. So you're pretty much familiar with NCA guides.
Yes, sir.
Right. Sife?
I took criminal law in January, so that was my first pre-plan, and I'm hoping to take admin and foundations in May and June. Okay, sounds good. Admin and foundation, very good combination, I would say, because you will see the interplay or interrelation between admin and foundation. Particularly, chapter 10 of foundations is just admin law. So you'll be killing two birds with a stone, if I can say that. Okay, so basically, I mean, the class, I expect it to be participatory, so feel free to jump in and ask questions along the way.
My name is Masood, and I'm the guide for Foundations of Canadian Law. Just a run through on the objectives of the course as provided by the syllabus. So foundation is interesting in the sense that it introduces you to other courses. So you'll find a whole lot of constitutional law, for example, under foundations. You'll find a whole lot of admin law under foundations, and you will see a number of cases that were used under criminal law in foundations as well, right? And I mean, for me, foundations was my first exam. So writing other exams, I sort of saw a number of the points or the subjects recurrent in other examinations. Other people prefer to write exams such as admin law and or constitutional law before they write foundations. But however you want it, you will see interrelationship and interconnectivity between the subjects, admin law and constitutional law in particular. Right. So the objective of foundation is to provide an overview and introduction of the Canadian legal system to candidates. So it's introduced you, basically, it gives you an overview, a bird's eye view of the Canadian legal system. So the structure of the Canadian legal system in our universities, I believe, we study courses like legal system or legal methods. So that is what foundation, that's essentially what foundation does. Gives an overview into the the Canadian legal system. Part of the objective as well is to review the various legal theories as they apply to Canadian law. So you will be seeing legal theories such as positivism, and we'll go in, when we look at chapter 1, we will see that. So the positivist school of thought, the naturalist school of thought, and unwritten principles of Canadian Constitution, for example, those high-level legal theories, we'll see, we'll come across them in this course. One other objective of the course is to introduce students to the overarching legal framework within which the particular areas of law studied in other course materials or other courses operate. You will recall that I mentioned earlier that when you go through admin law, for example, or constitutional law and criminal law, for example, you will see the legal foundations give you the legal framework through which these other courses operate, right? Then one other objective of the course is to introduce you to the sources of Canadian law. Recall that I mentioned legal methods. So a legal method, you see sources of law. So for the Commonwealth countries, for example, uses of law as the common law doctrine of equity and judicial precedent and all that. So under this foundation as well, we will go through all those sources of Canadian law, which is similar to other Commonwealth jurisdictions. One other objective of the course is to compare the different branches of Canadian government and to analyze the relationship between and among them. So the branches of Canadian government, we have the executive, the legislature, and the judiciary. So how do they relate with one another? Canada is unique in the sense that it operates a parliamentary system of government. In our jurisdictions or some other jurisdiction, we have the presidential system of government operating. So where there is clear delineation of power and responsibilities between the executive and the legislature, for example. But in Canada, there is a fusion of function between the Parliament of Canada and the cabinet ministers. So you see the prime minister, for example, is the the head of the executive, right? But the prime minister is also a member of the parliament. Cabinet ministers, they are also members of the parliament as well as being part of the executive. So how does this operate? You know, the queen, for example, who is the who is the head of the executive, at least ceremonially, is also has a legislative role to play as well. So how do these arms of government, how do they relate with one another? There is this debate as well about the power of the judiciary to sort of through judicial activism or interpretation of the law to um, change, if I can use that language, the will of the parliament. So when they interpret the law, they are deemed to be usurping the powers of the parliament. So how do we reconcile the powers of the legislature and the interpretative power of the court vis-a-vis the counter-majoritarian rule? So this course will also speak to that. One of the objectives as well is to provide applicants with an understanding of the Canadian treaty making process and the implementation of international law into domestic law. So what is the role of international law in domestic law of Canada, and how do treaties, how do they become part of Canadian law? So the treaty making process, we're going to talk about that in this course as well. One of the objectives as well is to provide applicants with an understanding of the special relationship of the Aboriginal people. So we have heard of if you've done constitutional law, even criminal law, you will have come across the language Aboriginal people of Canada. So who are these Aboriginal people, and what is their status within the Canadian constitutional framework? We would be looking at that. So we'll also be looking at the special relationship that the Aboriginal people have with the Canadian states, and how international instruments such as the UNDRIP has been used to sort of cement or protect the rights of the Indigenous people, and how did how is that operated? How is that applied in Canada, for example? We'll look at that. We'll also be looking at the functions of the courts, the judicial review process, and the approaches of interpretation. So whether the literal rule, what is the function of the court, and in interpreting the court, the laws, how do we ensure that they do not usurp the powers of the parliament? You know, we'll also be looking at that. So basically, those are the objectives that we'll try to achieve under this course. It's important to note that, I mean, we are all writing the exams for the or studying the course materials for the purpose of passing the exams. Of course, we want to gain knowledge, I imagine, and understanding of the framework of the Canadian legal system, because we want to be able to practice in Canada. So it's quite critical for us to be able to understand the legal structure. But I mean, our primary objective in this instance is to pass the examinations. So it's important to note that the exams are conducted for foundations. Basically they use 3 or 4 kind of approach. So you have the short answer questions, you have the problem questions, and you have the essay questions. You will see a lot of essay questions in in foundations, because I mean you have a number of articles, about 40 or more articles, I believe, and the cases as well. There are a number of cases on the foundations. So you will see, because it is the nature of the course is I mean there's a lot of theory, there is a lot of philosophy, there is a lot of jurisprudence content in the course. So you will see essay questions, so they can paint, they can give you a concept and say, okay, discuss this concept. So, or how does this concept applies, for example. And there are also problem questions, where problem questions are where they will paint a real life or hypothetical scenario and expect you to sort of apply your understanding of certain legal concepts to those scenarios. So you need to be able to understand the course and familiarize yourself with the course materials to decipher those the legal issues implicated in those scenarios. So there are also multiple choice questions or short answer questions, if you like. So those are sort of try to test your familiarity with certain legal concepts, so that they will know that I mean, you will not have the opportunity to explain. It's just a short answer. Do you know it or you don't know it? So once you are familiar with the course materials, I believe you should be able to answer those questions. Right. Any comments so far? Hello, can everyone hear me?
Yeah, I can hear you. No questions from her.
Yeah, I can. No question.
Okay.
I can hear you.
Right, good. So what I would do now, I like to go through the chapters and just basically talk about them. Do we have our syllabus?
Yeah.
I have mine.
Okay.
Yes, I have mine.
Yeah. Everyone, no one wants me to see them, and everyone is looking at me. Is that fair?
You look better than all of us. That's why.
Say that again.
You look better than all of us. That's why.
Okay, I will. We'll see how it goes. So I will just quickly share my screen and read through the chapters. So we'll start from chapter 1. Can we see my screen?
Yeah, I can.
Right.
It's a minute, please.
Sorry, I didn't catch that.
I said if you could just zoom in a bit.
Right. Better?
Yeah, it's better. It's better.
Good. Okay, so of course we know the materials that we'll read for foundations. I mean, is forces. Let me see. Yeah, forces, Dodec et al. Public law cases commentary and analysis, 4th edition. So I mean, if you have the time, please read it. I mean, I found the language of the text quite simple and straightforward. So I would encourage you to read it if you can. And thankfully, we have some months to the exam, so you should have some time. So we still have some weeks in February, or okay, we have 1 week in February, the whole of March, the whole of April, and I think 1 or 2 weeks in May. So that should be sufficient time to read the text. if you are so inclined. If we have, a summarized notes, Manuel's notes. It's available for purchase on our website. So that's a summarized notes, and you can reference that as well. There are also other courses. All cases are reported on Canly, and yeah, you will see once you read usually some of the cases are summarized about, so you'll see the crux of the cases. Once you read the first or two pages, I think you'll get the gist of the case. So other cases you might need to read further, and I think in some of the materials, reference has been made to particular paragraphs of of the cases where you should pay attention to, so you can also read that. I mean, there are supplemental materials if you are so inclined. You can read it. I am not sure about that. I mean, because you have the articles and the text. They are quite a handful. So, but if you are so inclined, the NCA has also provided supplemental materials, right? So we go into the chapter 1, so which is basic theories of law. So in chapter 1, we'll be talking about positivism and natural law. We'll be talking about feminist perspectives on law, critical legal studies, law, and economics. So that is in chapter 2 of forces. So we'll also do a run through of some of these articles: legal positivism, Arabs, Muslims, human rights, access to justice, and institutional trustworthiness, Robin, and also a run through of arrested injustice from the streets to the prison. Very interesting article by Robin Maynard. So I would like someone, a volunteer, to tell me what their understanding of positivism is. Anyone, any taker, just brief understanding. What do you understand by legal positivism?
Okay, so maybe based on what I've read so far, I would say in summary, I think the legal positivists, they look at law as the way law is. They don't think that we should look at, I don't know, I'm just guessing based on what I've read. They don't look at I guess like the moral underlying or why a particular law was made. They just believe that whatever the law is should be applied the way it is, and there's no need to start questioning. There's no need to start questioning how the law came about, and also whether it tallies with like moral standards in the society. So I think that's what like legal positivism is all about.
Okay, thank you. I mean, that's a good good summary, very good. So we'll introduce some other perspectives as well, but in terms of what legal positivism is, that's a good summary. Naturalism. Any other taker?
It's kind of like the opposite of like, well, not kind of opposite, but like natural law focuses on like morality and like what the justice system and the beliefs and stuff like that. So it's like pretty much like law comes from what is accepted by people, or what is morally accepted by people, and what is not morally accepted by people.
Good. Thank you very much, Tumi. That's also a very good summary. Yeah, very good summary about what's natural law or naturalism, if you like. is. So I'm riding on the back, but there's not much for me to say, other than to say that, I mean, legal positivism, the popular scholars there are John Austin, yeah, and for natural law, the popular scholars there are Aristotle, Thomas Aquinas, among others. So in this chapter just basically tries to tell us what is the relationship between legal positivism and natural law. It is important to understand that both concepts, and you'll see that at the end of the it tells us that positivism and naturalist school of law are not diametrically opposed to one another. They both help us to understand the relationship between law and justice. They are all concerned with the concept of law and justice, even though they differ in their approach. So as you've noted, sorry, excuse me. Right. So as you've noted, right? So positivism says that law is what has been written down, for example, or law is a command of the sovereign. And you say that the existence of law, or the existence and the validity of law, does not depend on the moral content of that law. It is a matter of fact whether a law exists or not. Whether it is a moral law, it is something that is different. It's another conversation. But law, the validity of law, is not determined by the morality of that law. So you can have an immoral right, and that will not make it less of a law. That is what the positivists say, right? There's a social fact, that law, for a law to be a law in its actual sense, it has to reflect the social values, the cultural aspirations of the people. If a law does not reflect the social values of the people, that law is not law. In fact, one of the commentaries, a bad law is no law. And the positivists say that, look, let's stop there. A law can be bad. It does not make it less of a law. And we see that law and morality have a relationship with one another, and the textbook referred to the cases of Ray Drummond Rain and Ray Noble and Wolf. I don't know if any of us have come across those cases, Ray Drummond Rain and Ray Noble and Wolf. Have we?
Yeah, I saw it.
Yeah, I have.
Yeah, good. So, and you'll see that in the first case, for example, the law, it was a discriminatory practice that there was a provision that prevents that property should not be sold to certain racial group, the Jews and all that, and the court struck down that provision as discriminatory because it says that the Canadian society embraces multiculturalism. So any law or any provision in any agreement that runs contrary to that multicultural nature of the Canadian society is an invalid law or invalid provision. So what did the court do in that case? Court referred to morality basis to hold to hold that law or to invalidate. While in the other case of Renewable and Wolf, a provision of a contract that prevents sale of land to certain racial group, the Jews as well, was also was held to be valid because the courts consider the fact that, look, it is a that clause in the agreement. The buyer of the land saw that contract before he bought it, right? And it is a the maintaining one racial group was critical to the value of that land, such that if the area becomes racially mixed, then it will affect the value of the land. And the court say, look, you seller, right? You knew the provisions or the restrictive covenants in the lease agreements before you bought it. Now, in breach of that covenant, then that will be contrary to the provisions of that lease agreement, right? So in both cases, we saw that in the first case, the court was concerned with morality, right? While in the second case, the court was concerned with the provision of the agreement. What did the agreement state? What did the parties sign on to? So, which is right, which is wrong, we don't know. It depends on your perspective of the law, right? So, again, here we'll also talk about the feminist perspective of the law. And what does the feminist perspective of the law, what is it seeking to achieve? It talks about how women have been generally disadvantaged in the enactment of laws. And we saw that in the case of Edward and Canada, the court was called upon to interpret the provision of the Constitutional Act of Canada, which appear to suggest that women could not be appointed into the Senate. You know, the language used by the Act was masculine, and from the early Canadian history, people appointed to the Senate, they've all been male, right? But that came where that provision, that practice was challenged, and the court said, look, using the naturalist approach to the interpretation of law, the law should not be fossilized into the Museum of Antiquities. It is a living tree. Let's use the concept of living tree. And what is a living tree? It means it can grow, you know, it can be modified. When it is overgrown, you can cut it and trim it to put it into shape, you know. So the court said in Edward and Canada, also referred to as the person's case, the court said that, look, we should interpret the law to conform with the journeys and aspirations of the people at every point in time, even though without necessarily amending the law, you know. So granted that in 1867, when the Constitutional Act, or the British North American Act, as it was then called, was enacted, maybe the Parliament had it in mind that it was only male that should be appointed into the Senate. But over time, the values of the Canadian society has changed such that we have now recognized that laws that are we've recognized that patriarchy what is not a cool thing, right? So how can we now remedy that situation? Is by interpreting laws in such a manner that conforms with the modern reality. And the modern reality is that we should accommodate both gender into the polity or into the social strata, such that what is sourced for the girls is also sourced for the gender. What a man can do, a woman should also have equal opportunity. So that is what the feminist perspective of law is all about. And there is a history to it. So it started from allowing the clamor. Previously, women could not vote, right? And over time, there was clamor that of universal suffrage, such that women were allowed to vote, right? So from that, it went to discriminatory practices against women in workplaces, so areas of maternity leave and all that, paying women less than you pay men, even though they do the same work and all that. So that feminist perspective of law is a sort of agitation from a human rights perspective to say all discriminatory practices against women, against people on the basis of sex or gender, on the basis of race, on the basis of religion, or any social matter at all, that should be discussed outrightly outlawed. So, and we also saw that because of Ara Morgenthaler, where the courts, the state tried to restrict abortion rights of women, and section of the charter to say, look, you cannot, when you prevent women from controlling their body, right, you are denying them their right of life, liberty, and security of their persons in contravention to section 7 of the charter. So, and I mean, abortion clinic was not allowed previously, and the state tried to regulate abortion and say before women can be allowed to carry out abortion, they have to get some licenses or some permission and what have you. So, and the court has held that all those unnecessary restriction violates the rights and liberty and security of the persons of women. So that is what feminist perspective of law tries to explain, to say that traditionally women were discriminated against, and over time the law was interpreted by the courts in a manner that affirms the rights of women, and the legislature have also responded by enacting laws that protect the rights of women, and the executive has also made regulations and carry out affirmative actions in such a manner that protect the rights of women and in the society, right? So in this chapter as well,
Excuse me.
and rights that law our practical.
Sorry.
Say that again.
You keep, I don't know, your
Go
internet.
ahead, please.
Your internet keeps freezing. Like I won't hear you for like seconds, and then you come back. So I didn't hear your concluding part from the feminist point and perspective. You were frozen.
Okay, sorry about that, Dara.
No problem.
I'll just take that again. So for the feminist perspective of law, what it seeks to achieve is to trace how women were subjugated into society, over time and the efforts that have been made to sort of right this wrong, and starting from the laws that were discriminating against women in such a manner to conform with the reality of the modern world, so as to ensure equal treatment of both both genders, right? And also how the different arms of the government, whether the executive or legislature or the judiciary, how they have also played their part in ensuring that women's rights are protected. So, for example, the judiciary, we saw in the Edward and Canada, the person's case, how they interpreted the provision of the British North America Act in relation to the appointment to the Senate to say, look, the he, notwithstanding that he was used in the British North America Act, that he implies a she as well, such that nothing prevents women from being appointed into the Senate. And we also saw in the case of R versus Mogentella, which says that when you deny women the right to abortion or you impose unnecessary restrictions on them, it is a denial of the security of their persons, contrary to Section 7 of the Charter. So we saw how the legislature of also passed laws, right, to protect women. And we also saw how the executive, in making regulation, in executing government policies, how they try as much as possible to ensure equal treatment and protection of women. So that is what the feminist perspective of law seeks to bring to the fore. Right? Did you catch that, Dara?
Oh yes, right. I got you.
Good. So I was talking about critical legal studies, and I said that basically what critical legal studies speak to is how law in practice reflects our practical and social experience and prejudices. So there is no necessarily neutrality in law, so to say. So how we interpret law, how a judge will interpret law, and we see that, I mean, very clearly if we refer to the United States of America, the Democrats or the Republican. So if you have a Republican judge or a Democrat, a left-leaning or right-leaning judge, they all have different views on abortion. For example, the right-leaning judge, they do not favor abortion, right? They favor death penalty and all that, while the left-leaning judge, they are more considerate towards abortion. They do not like death penalty and all that. So what does it tell us? It tells us that our perspective of law informs our interpretation and understanding of the law. So our social experience, if you grew up in a particular environment, the way you will look at things, the same provisions of the law. If I grow up in the US, or if I'm democratically leaning or left leaning, or another person is Republican leaning or right leaning, the way we look at the same provisions of the law would be different. So critical legal studies tells us that there is no neutrality in law. The way we look at law is informed by our social and cultural background and prejudices, and that that traditional formalism does not necessarily lead to justice. So saying that, okay, this is what the law says, I'm adhering to it strictly, does not necessarily lead to justice. And a whole lot of factors and considerations will be had before we can arrive at a just conclusion. So that is what critical legal studies seeks to achieve. Another point that was noted in the chapter is law and economics. So what is the relationship between law and economics? All right. What it says is that we apply basic economic principles to legal rules. And this theory tells us that, look, politicians don't mind them, they are not acting solely, they are not motivated solely by public interest. No matter what any politician or legislature tells you, don't believe them. If Trudeau is is giving some benefits, unemployment benefits or child benefits to you, don't mind him. It's not because he's a good man, right? It is because he wants to maximize political popularity. So it's because he wants the liberal government to remain in power for as long as possible. That is why he's doing all this social social intervention. So that is what economic school of law say. They say that politicians or political actors, they use the economic principle. And what is economic principle? You want to use resources efficiently. You want to derive the greatest benefits using the least resources. So it tells us that it is politicians that they act not solely, they are not motivated not solely by public interest, but to maximize political capital, just the same way we do things that we believe we will get maximum benefit from. That is, as a rational being, that is what you will do. You will do whatever you believe will maximize political or economic interests for you. And economic theories have been used to explain contract law, tort law, family law, property legislation, and all that. And when you are enacting when the legislature is enacting law of contracts, for example, what is at the back of their mind, part of the considerations that they have is using economic principles of efficiency. So that is what that law and economics is speaking to. So basically, interrelating economic principles with legal principles, right? Do we have any comments, question?
No question for me.
None for me.
Right. Thank you. So I will go through the articles, just summarize the articles, and there is a lot of what we mentioned earlier are amplified in the articles. So the first article is by Leslie Green, Legal Positivism, right? Leslie Green, Legal Positivism. So what does it say? The article states that the existence and content of law depends on social facts and not merits. That's what we mentioned earlier. So, and this is a view propounded by John Austin, and his forebearers Jeremy Bentham and the philosopher Hobbes and Hume. So we mentioned earlier when Tife, I believe, was defining what the positivism is, does not depend on morality, right? So yes, the article confirms that and says that whether law exists and the content of law, it doesn't depend on the merit of that law. It is only a matter of fact. It depends on social facts. One thing to note, in addition, which I think Ife did not mention, was that the view of the positivists, they are not saying that merits or the law merits of the law are unintelligible or unimportant. They are not saying that merits are not important or they are irrelevant. No, that's not what they are saying. What the positivists are basically saying that those are not the things that determine whether something is law or whether a legal system exists. So you can have a law that considers morality as part of its framework, right? But that is not key, critical to the determination of the existence of that law, right? John Austin also said that in the definition of law, that law is the command of the sovereign backed by force. And we see that in our various jurisdictions. When the parliament enacts a law, they will say they can enact a punishment section and say failure to comply with this provision, you will be fined XYZ or subject to a term of imprisonment of or so. So that is a characteristic of the sovereign. So, but the positivists say that law, when you are defining law, is a command of the sovereign and is backed by force. So, meaning that you do not have a choice, it's not subject to negotiation. And if you don't comply with that law, you would be penalized, right? Other philosophers that have contributed to positivism are Hans Kelsen, H.L.A. Hart, and Joseph Raz as well. And in their own contribution, so they moved from emphasizing on legislative institution to law applying institution. So they say that law is not necessarily what the parliament has enacted. Law is what the courts, who are the law applying institutions, what the courts say. And something does not become law until a court has made a pronouncement on it. And we see an aspect of that in our practice. So, for example, the language of the law or the words of the law are code. They are just there in the statute books. What brings them to life or what breathes life into them is how the courts apply them. So law applying institutions such as courts or executive arms such as the police, for example, who prosecutes offenders and what have you, right? The positivists also maintain that universal objective morality grounded in human nature do not contradict legal positivism. Just restating what we mentioned earlier, that look, you can have, they are not worse and opposite. So it is not that positivist is white or black and naturalist is white. So if you have universal principles or universal morality that is widely accepted, they do not mean that that does not contradict positivism. They are just saying that those are not the things that the morality of a law is not what determines whether something is law or not. So the article also speaks to two different character of the law from the positivist perspective. It says that it is, law is monistic, meaning that it has a single business, although it doesn't impose any obligation on the commander. So you say law is the command of the uncommanded commander. So the sovereign can make laws, but it cannot be commanded. So like the queen, for example, is above the law traditionally, and to the extent that Canada has that monarch, is a constitutional monarchy as well. So that applies very much in Canada. So the Queen is right up there. She is she commands, she issues out orders, and she cannot be commanded. And she's not bound by our own command. So it is for mortals that has to obey the law. So another character of the law, according to the positivist, it is that it is relative. It's not used in describing the law, can all be analyzed in non-normative language and can be in the form of power and obedience. So it can just say, you do this. You know, so when you use normative language, you are trying to set a standard of behavior, but they are saying that, look, the character of the law can be imperatival in the sense that it's just a command. It's just saying that you do X, Y, Z. Even where the law tries to put a structure, so that's can be implemented. It's not any normative rights. So, I mean, other people, other philosophers like Hans Kelsen, they've also criticized this perspective of law, and they are saying that, look, it is not at all time that law is a command of the sovereign. So a law that tells us to marry, for example, is not commanding us that everyone must go and marry. It's just telling us, okay, this is what we constitute a valid marriage, you know. So it is not at all times that the law commands the sovereign, and the fact that it is commands the subject, and the fact that it is not in the language of command does not make it less of a law, you know. So these are some of the contributions of Kelsen and all that. And HLA Hart, in his own contribution, says that, look, trying to now marry positivism and naturalist school of law says that authority of the law is social, that the criterion for validity in a legal system is practice, not norm. So, such that HLA Hart, in his own contribution, says that, look, yes, you are sovereign, right? You have the power to command everyone, but the authority of the law your authority is derived from the social inclinations or social imperatives of the people, such that if you command the people in such a manner that is antisocial or completely contrary to their values, that law will never be obeyed, right? That law would never be obeyed. So HLA Act says that, look, yes, we have to, yes, law is the command of the sovereign, but we have to be sensitive to the yearnings of the people, because the sovereign also derives its legitimacy from the people. And if the sovereign is so inconsiderate enough to make laws that do not reflect the wishes of and aspirations of the people, that law will not be recognized. And we'll see under that the role of recognition under HLA Hart's theory of positivism. So for Hart, legal system is norms all the way, but its root is social norm with custom. So HLA Hart, why notwithstanding that it is a positivist, says that you have to, the sovereign in enacting law has to pay attention to the yearnings, aspirations, and be sensitive to the cultural preferences and the moral preferences of the people. So in sum, we'll see that both the positivist and the naturalist, they are not against one another, so to say. So both of them try to seek to make us understand the relationship between law and justice and how we can use law to govern our society. That's the summary of that article. Do we have any comments?
No.
Right.
No comment.
Yeah, Tife, I haven't heard from you. Are you with us? Are you following?
Yeah, I am.
Good. Right. So we run very quickly to the next article. I think Arabs, Muslims, human rights, access to justice. Has anyone read that article?
I haven't read it.
No, I haven't.
Okay. Right. So quite straightforward article, and it speaks to critical legal studies. You know, we mentioned earlier that critical legal studies says that our understanding of the law or our interpretation of the law depends on our social context, on our background, on our world view. That those things, those soft things, reflect on our interpretation of the law, right? So the introductory part of the article says that law in the books is different from law in practice. Yeah, and it speaks to about 3 or 4 issues. It talks about access to justice. So procedural access to justice. What is procedural access to justice? It basically deals with the barrier of accessing the legal system. The article also talks about substantive access to justice. And what is substantive access to justice? Is about the relationship between law and justice. So if the parliament has made an enactment, is that enactment, does it achieve the aim of justice? Right? It is not at all times. So whether that enactment will achieve the aim of justice also depend on the interpretation that a judge or anyone interpreting those laws give to those to the enactments, right? The article also speaks to sociological access to justice. What does sociological access to justice mean? It deals with the sociological conditions that shape access to justice. So basically, the incentives and the disincentives that motivate people to seek legal redress and approach the court. So the article is saying that, and you saw the people that it targets. It says Arab Muslims. What does this tell us? It means people with minority social marking, which a number of immigrants will fall into, and says that human rights code exists, right, to protect and human rights code are passed by the legislature, not by the parliament, right? So the human rights code are passed by the legislature in each provinces, right? And it is to deal with certain things that cannot be dealt with by the charter. So the purpose or the essence of human rights codes across provinces is to prevent discrimination on the basis of race, gender, religion, and all, and certain social markers, right? But the article is saying that these things are not enough. The law itself, the human rights codes themselves, they are not the one that will guarantee access to justice. Because you can have this human rights code, but the sociological condition does not exist for people to approach the court and seek legal redress in court. And other factors that will aid people to get access to justice and seek redress from court are institutional trustworthiness, for example. What is institutional trustworthiness? It means the ability of the people to trust the legal system. Do people believe that when they approach the courts, they are going to get justice? So if people do not believe that they are going to get justice when they approach the courts, so of what essence are those laws when it cannot protect them? Right? That when people do not have trust in the system, then the cold letters of the law cannot protect them. And the article made reference to 13 cases, right, where people of where racialized residents of Canada approach the courts to seek justice, but out of the 13 cases, discrimination was found in 9 of those 13 cases, but the people, some of those victories did not translate to real victories, in the sense that some of them were upheld on appeal, right? And some of them, the court did not grant sufficient relief that made sense to the people. And these conditions, when people see these conditions, that look, Mr. A has approached the court, and this is what Mr. A got out of the court. They spent unreasonable length of time in the legal in the court system. Some of the in the 13 cases, some cases extended as long as 10 years or more. And those that were dispensed with overtime in a short time, the courts did not find discrimination, notwithstanding that act or the act complained about were clearly discriminatory. But because the legal system, or the judge was from a different background and has never understood the judge has never been discriminated to start with, so the judge does not even understand what discrimination is. So and that sort of affected the judge's understanding and appreciation of the issues in those cases. And even where the court or the judge found discrimination, it gave remedies that were completely insufficient, And the article says that all these issues, when people do not trust the system, they've learned from other people's experience to say, Mr. A approached the court, did not get justice. So why should I take that route, that unsuccessful route? Mr. B approached the court, spent so much time in the legal system, and at the end of the day, did not get justice. Mr. C approached the court, spent inordinate resources, and don't forget that these people are immigrants with limited resources, trying to settle into a new system. So having spent so much resources in paying lawyers and filing cases, at the end of the day, the court did not give remedy to the litigants, notwithstanding that there were clear discrimination against the litigants. Then all those factors affect the willingness of the litigant to approach courts. And another factor is litigation stress. So I don't know anyone that likes to spend inordinate time in court. And this thing also has sort of psychological effects on the litigants. You know, when you are so convinced about your case, when you have been clearly wronged, and the system does not even give you a remedy. So this doesn't bode well for access to justice. So what the article is saying is that it is not sufficient or is not enough to just have human rights codes or to have legislation that seeks to guarantee access to justice without having without having a general consciousness or a general framework that promotes access to justice. So the system should have a process or a framework that allows racialized people to be part of the decision-making process, for example. And we'll see that explained better, I believe, in chapter 9 of the course material, saying that the perspective that the judiciary should be reflective of the population that it is adjudicating over. So if you have a multicultural society or community, then it is only sensible to have a multicultural bench or multicultural judiciary. But if you have a multicultural society, but you have an all-white judiciary, that does not guarantee access to justice. And because all the judges that are adjudicating, they've never seen discrimination. They've never been discriminated against, whether in workplaces or in the community. So how well can they really understand discrimination or apply the human rights code that seeks to eliminate discrimination of any form or any kind? That's the summary of that article. Do we have comments?
No comment. No comment for me.
Right. So the third article is and I mean when I wrote my exam, the question around this was framed on access to justice, to say write a memo to your to the member representing you in the legislature about how the human rights code, how it is insufficient to guarantee access to justice, and what changes needed to be made for that human rights code to guarantee guarantee access to justice. So it was the question was framed around that. So in that kind of question, so you will basically be talking about I mean, how our experiences influence the way we interpret the laws, and how the laws they are not sufficient in themselves to guarantee access to justice, and there are a whole number of facts, sociological facts, procedural aspects, and what have you. And you talk about the experiences of the people of litigants that were referred to in the cases in the article, and just sort of frame it around that. Right. A related article is by Robin Maynard, Arrested Injustice: From the Streets to the Prison. Right. I mean, I like this article a lot. I mean, so it's very similar to the one that we just ran through, and it's saying that talking about the experience of Black people, you know. The other article talked about Arab Muslims and all that. here talked about the experience of Black people and saying that Black people in Canada are subject to invasive police surveillance that makes it difficult to exist in public space. So being Black in Canada is synonymous to being a crime. And this is something that is quite mainstream, and statistics suggest that a Black person is more likely to be stopped 60 times more than a white person, you know. And the article sort of tried to trace the history of this to say it dates back to colonialism, you know, when Black people were imported from or transported from Africa to North America and Europe. Over time, they fought for their freedom, right? And some of them escaped from should I say custody, right? And the police was set up to look for all these escapees, you know, those that have unlawfully escaped from custody. So the police were part of the people that were looking for them, such that if they see any Black, so they want to know what is your status, were you rightly emancipated, or did you escape from custody? So that's historical bias has been translated or transported to modern times, in the sense that when there is a crime, what the police do is to go to Black communities and look for the criminal in those Black communities. And the article says that, look, it is not that Black people are more prone to commit crime than white people. It is that racial prejudice that is making the police find criminals in the Black community, because it is a self-fulfilling prophecy. If you are looking for crime in Black communities, of course you are going to find crime. You're going to find criminals in those Black communities. But if you are truly looking for crimes, you should not be informed by racial marking. The same effort that you use to look for criminals in Black communities, use the same effort to look for criminals in white communities, and you will find as much criminal in white communities as you have found in Black communities. So, but if you did not go to Black communities, if the only people you are stopping, doing stop and search, you are implementing stop and search policy against is the Black people, then of course it is only natural that you are only going to find people that do not have a driver's license or have expired insurance papers. It's only natural that you will find them in Black communities, because you are not stopping any white community, any white person, right? I remember, just on a lighter note, when Donald Trump was being asked about the number of COVID cases in the US. What was his response? His response was that it is testing. That is because you are testing. That's why you are finding COVID cases. That the more you test, the more COVID cases you will find. If you stop testing, you are not going to find any COVID cases. So the same way, the more you stop or you go to Black communities to look for criminals, you are going to find. But if you stop looking for criminals in Black communities and you expand your search to anywhere that you can find criminals, you will see that Blacks are not necessarily more prone to commit crimes than the white population. So, that's basically what the article tries to speak to, just saying that, I mean, the Canadian police, they profile Black people for crimes, and this is a form of discriminatory practice against the Black community. Do we have any comments on that article?
No comments.
Okay, I want people to also talk. I mean, if you've read it, if you have different perspectives or what have you, please feel free to bring it on board. It's supposed to be a participatory class. Okay, so I go to chapter 2, Indigenous people and the law. I'll just share my screen. Can we see my screen?
Yeah.
Right, thank you. So Indigenous people and the law. In this chapter, we'll look at the Aboriginal rights and title, Indigenous self-government aspirations, and the modern treaty making process. So again, the material to that for that is Forces chapter 3, right? Who are the indigenous people? Does anyone want to try? Who are the indigenous people of Canada?
People that were in Canada. Okay.
Can you take that again, Tommy?
So people that were okay. For Europeans, okay.
Right. That's correct. Thank you very much. So the indigenous people of Canada are the people who occupied the space now known as Canada before the advent of the European and other people like you and I. Special attention in this chapter is to section 35 of the Charter and section 91 sub 24 of the Constitutional Act, the British North America Act. So section 35 of the Charter and section 91 of the Constitutional Act. I would just like us to read the section 35 so that we can just situate it. Let me share my screen and I will ask someone to read. So I need any section 35. Can someone volunteer?
Section 35. Oh, Dara, you go ahead.
No, go ahead. It's fine.
Oh, go ahead.
Okay. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Definition of Aboriginal peoples of Canada, subsection 2. In this act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis peoples of Canada. Land Claims Agreement, subsection 3. For greater certainty, in subsection 1, treaty rights include rights that now exist by way of land claims agreements or may be so acquired. Oh, thank you for the name. Aboriginal and treaty rights are guaranteed equally to both sexes. Subsection 4, notwithstanding any other provisions of this act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. Am I to continue?
That's fine. That's fine. So thank you very much. I mean, this is a very critical aspect of foundations. I mean, Section 35. You find it in foundations. You find it in constitutional law about the rights of the Aboriginal people. So the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So what this does is to constitutionalize or entrench the rights of the Aboriginal people. So it means that you cannot, the government cannot violate the rights of the Aboriginal people without the government contradicting the Constitution. And you know, Constitution is the ground norm, right? And it is from there that all other laws derive their legitimacy. So where the rights of the Aboriginal people are violated is a breach of the highest law of the land, right? So, and what are the existing rights of the Aboriginal people? And what does it mean that it has been recognized and it has been affirmed? What does affirmation mean? What does recognition mean? And what does existing Aboriginal and treaty rights, what does it mean, right? So that is what this chapter tries to explain, right? So we have the Aboriginal rights. It speaks to two issues: Aboriginal rights and Aboriginal. So what do we understand by Aboriginal rights? Does anyone want to try?
I think it just says in the name, the rights attributed to Aboriginal people in Canada right now.
Okay, thank you, Tomi. So Aboriginal rights, it speaks to their fishing rights, their hunting rights, their cultural rights, their grazing rights, you know, so their right to practice their culture, to practice their religion, their right to fish, their right to farm, to cut down trees. I mean, things that they culturally do. Those are that is what is meant by Aboriginal rights. While Aboriginal title refers to their ownership of the land that is now Canada, you know, so title to land, right, and land claims agreement and all that, that is title. Why their right is their cultural right, fishing, hunting, grazing, religious practices, and what have you. So both have been recognized and affirmed by Section 35 of the Charter. So, and as I said earlier, it's the recognition and affirmation mean that those rights cannot be violated. They are constitutionally protected, Right. So we talked about the indigenous people or the aboriginal people. We say they are the people that were here before the European and all of us, right? And that's prior to the advent of the Europeans, the Aboriginal people, they occupied the land and they could do whatever they needed to do without interference from other people, right? Then came the European, who asserted sovereignty on the land that belonged to the Aboriginal people. And how did they do that? Some of them they did through signing of treaties of peace and friendship. Most areas of Canada, aside, I believe, British Columbia, where a lot of the native people refused to sign treaties of friendship with the European. Most other places, they signed treaty of friendship whereby the indigenous people surrendered their sovereignty over themselves and over their land to the European people in exchange for protection. And that was the mode that was adopted across Commonwealth countries. For example, the European, the British with their gun, they come and offer you protection and friendship in exchange for control of your land. So that was the same thing that was done in Canada. But over time, and in this agreement, most of them uh, the sort of guarantee certain rights to the Aboriginal people, their fishing rights, and their by the European. And what was their excuse for breaching it? Those treaties are subordinate to laws. The subsequently after the agreement was contrary or over that sort of effectively over contradict or override the treaty that have been signed. The European will now prosecute the Aboriginal people under those laws. And that was what happened in the case of R and Silly, where is a Mi'kmaq chief, one of those tribal people in British Columbia, was prosecuted for fishing in prohibited waters, notwithstanding that there was a treaty that that community could fish in that water, So as well, along with the exertion of sovereignty, the Crown compelled the Aboriginal people to relocate, right? They pushed them to the reserve, and we'll go through that in one of the articles. They pushed them to the reserve, and they also assimilated them. They did not allow them to speak their languages in those reserves, and they dispossessed them of their land. They built residential schools for them where they separated children from their parents, and the children could not learn the culture and the languages of their parents, So that was how the European related with the Aboriginal people. And part of the reconciliation process was now to say, let's entrench or enshrine the protection of the Aboriginal rights and title in the Constitution, such that it will be a grave offense for the government to violate this right. And we talked about the existing Aboriginal rights and title. So here we will be dealing with what are those existing rights, So the fact that they were fishing through, they use maybe hook to fish in olden days, doesn't mean the Aboriginal people cannot use modern techniques to fish. No, it doesn't mean that. So those are any practice that the Aboriginal people used to do in the past, the modern version of those practices are also recognized and affirmed. So, and what is the test? We now look at the test of determining if something is an existing Aboriginal right. One of the tests is that it has to be intrinsic to their Aboriginal nature. So it is not every practice that is recognized and affirmed. It is practices that are intrinsic to their aboriginalness, if I can use that word. So those practices that forms part of their get-up or part of their intrinsic characters. So, for example, we know that the Aboriginal people, they used to fish. We know that they used to hunt. We know that they used to practice certain culture. So those things that are intrinsic to their aboriginalness are the things that are recognized and affirmed by the Constitution. Very quickly, I think we just have less than summary get a sense of it, you know. So one of the article, the first article, summary of the final report of the Truth and Reconciliation Commission of Canada, honoring the truth, reconciling for the future. So this just basically deals with all the steps that were taken by the Canadian government to assuage the Aboriginal people and to sort of right the wrongs that have been committed against them over time. And that was part of what led to, and it also chronicled how the charter was drafted to sort of protect the rights of the Aboriginal people. John Burroughs' Article 7 gives to revitalizing living laws through Indigenous legal practice. So John Burroughs told a story about an Aboriginal person and basically saying that Aboriginal laws can be part of Canadian laws. So there is nothing that says that Aboriginal laws is contrary to the Canadian laws. Then we also look at the United Nations Declaration on the Right of Indigenous People, the UNDRIP. I think it is a 1995 or 96 declaration by the United Nations, which sort of protects and recognize the rights of Aboriginal people worldwide. To say Indigenous people in every nation, and I think they are most common in the US, in Canada, New Zealand, Australia. I mean, you'll find a lot of a sizable number of indigenous people in those countries. And of course, in our various jurisdictions, particularly Commonwealth nations, people that are traditional to a community, the United Nations Declaration tries to protect their right to say they are independent people, they deserve their rights and culture deserves to be protected, and they are also recognize the discrimination that they've encountered or suffered over time, and just basically saying that the rights of these indigenous communities globally should be protected. They have the right to self-determination. They have the right to protection of their culture. They have the right against assimilation and discrimination and all that. So that's what the declaration just basically tries to achieve. Then we see the next article is the by Hayden King, UNDRP Fundamental Flaws, and it talks about the flaws or the gaps in the UNDRP. And it says that, look, one of the first to come up with this declaration, right? And secondly, even countries have not domesticated these United Nations declarations into the corpus of their local laws in order to give it legal effect, because it is just a declaration. It is not enforceable if it has not been domesticated. It also depends for its validity for nations to sign up to it. So if a nation says that I'm not signing up to the United Nations Declaration, then it is not bound by that declaration. So of what essence is that declaration if it has not if it gives nation an election to sign up to that declaration? And one other flaws that the article identified is that a number of the rights in that article can only be exercised with the permission of the state actors. So, and it is these state actors that are preventing the exercise of this aboriginal right. So when the oppressors, you need the permission of these oppressors to exercise your right. So of what purpose is that declaration, right? And a whole lot of so basically the UNDIRP. Then another article, the next article is the UNDIRP, a human rights to self-government over First Nation, by Naomi Walkan. What the article just basically saying is that there was this case of First Nation Child and Family Caring Society of Canada versus Attorney General, a very important case in the history of the First Nations people of Canada. The case found that the Department of Indigenous and Northern Affairs, that in the design, management, and control of child welfare services on the reserve, did not consider the interest and the rights of the indigenous people, and that the way the program was implemented in the funding formulas caused harms and discrimination against the indigenous people. And it's saying that if the government sets up a program or an agency to protect or to advance the cause of the indigenous people, and the programs of that agency are implemented in a way that is not sensitive to their cultural, historical, geographical needs and circumstances, then that program violates Section 35 of the Constitutional Act, because Section 35 protects the rights, the existing rights and title of the indigenous people of Canada. So, I mean, in summary, that's what that article says. Then the next article is by Brenda Gurn, implementing the UN Declaration through domestic legislation. Sorry, I'm rushing because, I mean, we're still in chapter 2 and I just have about 15 minutes to go. So this article argues that Canada missed a very important chance of providing global leadership in the recognition of the rights of the indigenous people. The article referred to a bill sponsored by a member of parliament, I think Bill C-262, which sort of tried to domesticate the UNDRIP. Unfortunately, that bill did not get into did not become law basically, and the author believes that that bill was a milestone that Canada missed. That if the parliament had adopted that bill and passed the bill into law, it will have cemented Canada's leadership in the protection of the rights of Indigenous people. I mean, some other people criticize the bill. They do not necessarily agree with the author, and they believe that Section 35 is sufficient. In fact, does more than the UNDRIP we can do, because the UNDRIP did not take into consideration the peculiarities of the Canadian society, and that it's just made a whole lot of declaration without which is supposed to be global in its implementation, but without localizing it to domestic communities. And they argued that adopting that bill will have made Section 35 uncertain, and will have come with a whole number of confusion into Aboriginal laws or regime in Canada. So, I mean, argument for and against. I think the last in the January, or is it February exam, a question was an essay question was asked around this article about how the impacts of about the criticism of the UNDRP, and saying basically that Canada missed an important step in taking global leadership in the implementation of the rights of Indigenous people. Do you agree, or something around that kind of question? So, I mean, you can pick either side or argue for both sides in responding to that kind of question. Again, that is an essay question. Like I said earlier, because the course deals with concept, theories, and what have you, so you will see a lot of essay questions in the examination. So I mean, just a run through of the cases. The case of Rio Tinto on Aboriginal rights. Rio Tinto talks about the duty to consult. You know, part of the constitutional framework in Canada is that if the government of Canada wants to infringe on the rights of the Aboriginal people, it has a duty. Part of the protection, the implication of protection of the rights of the Aboriginal people is that before the government can infringe on their rights, it has to consult the Aboriginal people. It has to consult and accommodate them. And Rio Tinto says that, look, the duty to consult arises whenever the government has an actual or constructive knowledge of Aboriginal rights. So let's say, for example, the government wants to ban certain practices, you know, and they know that those practices are carried out by Aboriginal people, whether they know actually or constructively. I mean, if whether they suspect, let them even not be sure, they just suspect that, oh, this aspect of the prohibition might affect the rights of the Aboriginal people, then the duty to consult would have arisen. That is what Rio Tinto said. Then in the case of Chipawes versus Enrich, it says that the duty to consult is the crown. but an administrative body. So it can consult on behalf of the crown. So it doesn't have to be the crown itself, maybe the government of Canada or the government of a province that must do the consultation. If an administrative body has been set up by the government, that administrative body can consult on behalf of the government, and that duty to consult would have been fulfilled. Very quickly, in Mikisu Crew versus Canada, it says that duty to consult does not arise in legislative actions. So it's only in executive action that the duty to consult arises. So if the government, if the parliament or the legislature wanted to pass a law, they do not have a duty to consult the Aboriginal people in order to pass the law. The next case is Patchen versus Dean, First Nation, which says that, judicial review of Aboriginal matter is on the basis of reasonableness. So it's not on the basis of correctness. When the court is interpreting or adjudicating on an Aboriginal matter, the standard of review is correct, is reasonableness. And we'll talk about standard of review in chapter 10. Then the next case is the Queen versus Richard Lee DeSaltel. Very interesting case. The case has gone on appeal. It's a Court of Appeal decision. It's gone on appeal to the Supreme Court. The case talks about an American citizen who has come to Canada to claim Aboriginal rights. You know, he's not a citizen, he's not a Canadian, right? He's an American, but he's claiming Aboriginal rights in Canada. So interestingly, the Court of Appeal held that the Section 35 deals with does not guarantee the right to Canadian people alone. So it doesn't say it has to be citizen. What Section 35 guarantees is the right of the Aboriginal people. And we know that, North America, there could be border people who were part of Canada, but because of the border now, they now fall within US, but they can trace their origin to Indigenous people of Canada. So what the case says is that Section 35 also covers those people. So the right is not guaranteed to only Canadians, right? So it can have cross-border. Interesting, and we'll see how the Supreme Court will decide on that case. A related article to that case was written by Scott Carrere about whose sovereignty is it anyway, the borders of Aboriginal rights along the sovereign borders of Canada. So just basically analyzing that case and saying it will be interesting how the Supreme Court will view it, because when the border was divided and some Aboriginal people now fell outside of Canada, does it take away the fact that they are not within the borders of Canada anymore? Does it take away their aboriginalness? So it doesn't. The answer, according to the Court of Appeal in that case, is that it doesn't take away their aboriginalness. And like I said, we'll see how the court or how the Supreme Court will interpret that provision. Very quickly, we go to the case of Newfoundland and Labrador versus Oceanaut, and this deals with access to justice and the Aboriginal title claim. And it's saying that in Aboriginal title claim, the court should adopt a liberal approach. So in that case, an objection was raised to the jurisdiction of the court, whether it is the court in Quebec or the court in, I think, in Newfoundland, which of the courts has jurisdiction. And what the court says is that, look, when it comes to Aboriginal title claims, the court should adopt a liberal position such that even though the jurisdiction does not squarely fall within a particular court, the court should be allowed to adjudicate on that. All the principles of accommodation of the Aboriginal people. So you shouldn't strictly apply the law against them. The case of Shikotin Nation and BC deals with how to prove Aboriginal title. So you talk about a long-term possession, consistent possession, continuous use, and all that in order to prove that title. So you have to show that the Aboriginal people, they've used the land from time immemorial, and the proof doesn't have to relate to a particular land. If they are using that even a tract of that land, it is part of the acceptable proof of title. So I'm not quite sure. I mean, that's Psalms chapter 2. We just have like 2 more minutes to go. I'm not sure if we should go into chapter 3. I welcome comments from anyone. I mean, comments, suggestion, contribution.
Thank you. That was a lot. In regular going to go and all the.
Sorry, Tommy, I'm struggling to hear you.
Okay, can you hear me now?
Yeah, better.
So I said in the class, are we going to go through the cases and the articles in like more detail than we did today?
Absolutely. So in the intensive class, which will start sometime in March, we would go into the cases and articles in greater detail. So this is just an introductory class to sort of introduce us to some of the topics, the cases, the concept, and what have you. So we would go into greater details in the intensive class.
Okay, thank you.
Yeah. Any other comment, question?
Yeah, I have a question. I just wanted to find out, like, how is the structure of the class going to be in relation to like the materials?
Okay, so the structure of the class, I mean, we have video, we have recorded video for all the chapters. So that is one option. Another option is we can have the class like this, and we do have it. I can't. Let me try to look for the timetable. We have starting from. Say that again.
We have it every Saturday.
Yeah, every Saturday. So I think we have about 4 to 5 classes to try to cover the topics. And we do have videos, recorded video, like I mentioned. So if your time is not, if the timing of the class is not suitable for you, or you think the class is too fast or too slow for you, we have recorded videos as well. We'll send you a link and give you access to those videos. And after the classes, I think we'll also have what's it called? We'll have the exam preparation class as well. So just to treat some exam questions. And if we also offer private classes, so if you don't like to be in group of in a class like with other people and you prefer private classes, so please send us an email at inquiries@ncaguides.com, and we'll be happy to accommodate you, so that way you have a one-on-one session with the guide and you can feel maybe more relaxed or something. So we have students who prefer that as well. So yeah, I don't know if that answers your question, Tife.
Yeah, it does. Thanks.
Good.
I have a question. So, do we get like I know in some of the previous NK classes, we get like a summary before we start the class, like a summary the day before, and then at the end of everything, we get something like a framework, like an step framework. Do things like that apply here in foundation?
Oh, okay. Thank you, Dara. No, it doesn't apply for foundations. Because I mean the structure of foundations is quite different. The materials are quite a lot. What we do have is the manuals notes, which is a summarized notes of the articles and the course materials, and that's I mean that is available for purchase on our website. But in terms of summary notes for before, after the class, that doesn't apply for foundations.
Okay.
Any other question? Okay, I guess that's where we'll draw the curtain for the introductory class. I look forward to you all registering for the intensive class. And if you have any question, any inquiries, please feel free to drop me a line at Masood, MASUD, at ncaguides.com. Again, Masood, MASUD, at ncaguides.com, or send an email to inquiries@ncaguides.com, and we'll be more than happy to attend to your queries. Thank you very much for attending, and please enjoy the rest of your day.
Thank you. Bye.
Thank you. Bye.
Thank you.
Bye.
Thank you.